Imagine a courtroom where logic dies, and the law is written by someone who had a very strange lunch. The American legal system is supposed to be our bedrock, but occasionally, judges throw the rulebook into a wood chipper. From declaring bees to be fish to ruling on whether a burrito is a sandwich, the bench gets weird fast. We've scoured the archives for the most baffling, hilarious, and nonsensical rulings in history. Get ready for 50 moments where common sense officially left the building. 1. In a case that sounds like a supernatural thriller, a Pennsylvania judge once officially ruled that a man was legally dead, despite the man standing right in front of him. Because the individual had been missing for years and his family had already settled his estate, the court refused to overturn the death certificate. The judge literally looked a living, breathing human in the eye and told him that, on paper, he didn't exist. It took years of legal fighting for the ghost to win back his right to have a bank account and a social security number. How do you even begin to prove you're alive when the law says otherwise? 2. In a very Florida ruling, a judge decided that a man was allowed to keep a 600-pound pet alligator in his backyard pool because it was an emotional support animal. The man had the paperwork to prove that the gator helped him with his depression. Despite the neighbors' obvious concerns about their poodles being eaten, the court initially favored the owner's right to his scaly therapist. Do you think a prehistoric predator can actually provide emotional support? 3. A judge in New Hampshire once ruled that a man was legally allowed to live in a treehouse to avoid paying property taxes on a dwelling. Since the structure wasn't connected to the ground and didn't have a traditional foundation, the man argued it wasn't a house under the local tax code. The judge agreed that the law was poorly written and allowed the modern-day Tarzan to stay in his canopy home tax-free for years. It's a brilliant example of how a literal interpretation of the law can lead to some very high-altitude living arrangements. 4. A judge in Michigan once ruled that a man was legally allowed to sue his own mother for emotional distress caused by her bad parenting. The son claimed that his mother failed to buy him birthday cards and didn't provide enough emotional support during his childhood. While most of us just complained to a therapist, this guy took it to the bench. The judge actually allowed the case to proceed initially, proving that in America, family drama isn't just for Thanksgiving. It's for the courtroom, too. Could you imagine taking your mom to court because she forgot your favorite snack at the grocery store? 5. A judge in California once ruled that bees are technically fish. Under the California Endangered Species Act, protection was traditionally reserved for birds, mammals, amphibians, reptiles, and fish. In an effort to provide legal protection to 4 species of bumblebees, the court utilized a loophole where invertebrates are grouped under the category of fish. So, in the eyes of the California legal system, a buzzing insect is basically a trout with wings. Does this mean I need a fishing license to shoo a bee away from my soda? This is peak legal logic. 6. Back in the 1940s, a judge ruled that it was perfectly legal for a person to be fired for being too attractive. While we usually hear about discrimination for the opposite, the court found that if a person's beauty is considered a distraction to the workplace or causes jealousy within the business owner's marriage, the employer has the right to let them go. It's one of those rare moments where being a 10 out of 10 is actually a professional liability. Could you imagine explaining that at your next job interview? Sorry, I'm just too gorgeous for the accounting department. 7. In one of the most bizarre displays of creative sentencing, a judge once ordered a man who stole a bicycle to dress up as a chicken and walk through town. Instead of traditional jail time, the judge decided that public humiliation was a much more effective deterrent. The man had to carry a sign that said, "I am not a chicken for stealing, but I am for not going to jail." It's an oddly medieval approach to justice that makes you wonder if the judge was just bored that day. Would you rather spend a weekend in a cell or an afternoon in a feathers and beaks suit in public? 8. A federal judge once ruled that the Happy Birthday song, yes, the one everyone sings at every party ever, actually belongs to the public. For decades, a massive music corporation claimed they owned the copyright and collected millions of dollars in royalties every time the song was used in a movie or TV show. The judge looked at the history and realized the owners never actually had a valid claim to the lyrics. It was a massive win for birthday parties everywhere, finally freeing the world from the fear of a copyright strike during a cake cutting. It took a court to save the party. 9. In 1893, the Supreme Court officially ruled that a tomato is a vegetable. Botanically, it's a fruit, but the law doesn't care about your science textbooks. At the time, there was a heavy tax on imported vegetables but not on fruit. To protect American farmers, the court decided that since people eat tomatoes with dinner and not as dessert, they are legally vegetables. Imagine being a world-class scientist and having a judge tell you that biology is subjective because of a salad. Does this mean if we start eating Snickers bars for dinner, they legally become a healthy legume? 10. A judge in Florida once ruled that a man could not be evicted for having a 12-foot-tall skeleton in his front yard year-round. The Homeowners Association claimed it was a nuisance and violated the aesthetic harmony of the neighborhood. The judge, seemingly a fan of the macabre, ruled that the skeleton stayed because the HOA rules were too vaguely written to specifically ban giant plastic bones. It's a victory for weirdos everywhere. 11. In a display of judicial sass, a Michigan judge once ruled that the middle finger is a form of protected free speech. A woman was pulled over for speeding and, as she drove away, she decided to flip the officer the bird. The officer pulled her over again and gave her a harsher ticket. The court ruled that while flipping someone off is definitely rude, it isn't illegal. The judge essentially told the police that they have to have thicker skin because the First Amendment covers your right to be a jerk to authority. It's the ultimate legal shield for being petty. 12. A judge in Michigan once ruled that a woman was allowed to sue her own insurance company for a car accident that she herself caused. The legal gymnastics required for this are incredible. Since she was the injured party, but also the insured party, the court allowed her to act as two different legal entities to get the payout. It's the ultimate trust nobody, not even yourself moment. If you could sue yourself for every bad decision you've ever made, how much money would you owe your own bank account? 13. In 2005, a judge in Nebraska famously presided over a case where a state senator sued God. The lawsuit sought a permanent injunction against the Almighty to stop causing fearful floods, egregious earthquakes, and terrifying tornadoes. The judge eventually dismissed the case, not because God was innocent, but because the defendant didn't have a legal home address where he could be served papers. It's a masterclass in bureaucratic logic that proves even the creator isn't above the law, provided you can find his mailbox. It's probably the most ambitious litigation in history. 14. A judge in Colorado once ruled that dumpster diving is a legally protected activity as long as you aren't trespassing. The ruling stated that once you throw something away, you have abandoned your expectation of privacy regarding that item. This means that if a private investigator or a curious neighbor wants to go through your trash to find out your secrets, they are technically within their rights. Does the thought of someone legally digging through your Tuesday night leftovers make you want to buy a high-end paper shredder? 15. In an incredibly strange property dispute, a judge ruled that a man owned a piece of the sun. The man had filed a claim with a local registry office, and when no one contested it, he took it to court to legitimize his ownership. He then started trying to charge people for solar energy usage. Surprisingly, the judge didn't immediately laugh him out of the room, though the bill was eventually tossed out because you can't exactly evict a star. It goes to show that if you're bold enough to claim a celestial body, the legal system might just take a second to consider it. 16. A judge in Ohio once ordered a man to spend a night in the woods without any modern luxuries as punishment for abandoning a litter of kittens. The judge believed that the best way to teach empathy was to make the offender feel exactly how the animals felt: cold, lonely, and scared. This eye for an eye judicial style is famous in certain districts for being much more effective than a standard fine. It turns out that a night under the stars with no sleeping bag is a great way to rethink your life choices and your treatment of pets. 17. In a case about the definition of meat, a judge ruled that Pringles are not actually potato chips. In the UK, the court decided that because Pringles are made from dough and have a very specific, non-natural shape, they don't qualify as chips for tax purposes. This saved the company millions. In the US, similar logic has been applied to various food items to help corporations dodge taxes. If a chip isn't a chip and a bee is a fish, do you think any of the labels in your grocery store are actually telling the truth? 18. A judge in Ohio once ordered a woman to walk 30 miles in 48 hours because she failed to pay for a taxi ride of the same distance. The judge offered her a choice: jail time or the walk. She chose the walk, which was monitored by a GPS ankle bracelet. This poetic justice style of ruling is becoming a trademark for certain judges who believe that the punishment should fit the crime in the most literal way possible. It turns out that a free ride can end up being the most exhausting workout of your life. 19. A judge in Texas ruled that it is perfectly legal to own a flamethrower, but you can't use it to melt snow on a public sidewalk. While Texas is generally pretty relaxed about what kind of hardware you can keep in your garage, the court decided that using a device that shoots 20-foot streams of fire in a residential area constitutes a disorderly conduct risk. It's a weird middle ground where the weapon is totally fine for your collection, but the chores are strictly restricted. Apparently, fire-breathing snow removal is where they finally draw the line. 20. In a landmark case for the lazy among us, a judge ruled that an employee who was injured while excessively walking to the break room was entitled to workers' comp. The employer argued that the employee was taking a deviated path and wasn't technically working. The judge disagreed, stating that the act of seeking coffee or a snack is an inherent part of the American workday. It's nice to know that the law officially recognizes our need for a mid-afternoon granola bar as a protected human right that the boss has to pay for. 21. A judge in Nevada once ruled that a man could marry his laptop, at least in theory. The man tried to argue that if certain groups could marry, he should be allowed to marry his MacBook. The judge eventually dismissed the case, but it sparked a massive debate about the legal definition of personhood. While the ruling didn't go in the man's favor, the fact that it reached a judge at all shows how far some people are willing to push the boundaries of freedom of association. It's a strange world when your computer becomes your legal spouse. 22. An Indiana judge once had to settle a heated legal war over whether a burrito is technically a sandwich. This wasn't just a late-night debate. It involved a non-compete clause in a shopping center lease that forbid other sandwich shops from moving in. The judge ruled that a burrito is not a sandwich because it's made with a single tortilla rather than 2 slices of bread. This created a legal precedent that separates the world of wraps from hoagies forever. If you were the judge, would you have ruled based on the bread, or would you have just followed your stomach's heart? 23. A judge in Missouri once ruled that a man who illegally killed hundreds of deer had to watch the movie Bambi at least once a month during his 1-year jail sentence. The judge wanted the poacher to feel the emotional weight of his actions by watching a cartoon fawn lose its mother over and over again. It's psychological warfare disguised as justice. Does watching a Disney movie count as cruel and unusual punishment for a grown man? 24. In a bizarre tax ruling, a judge decided that professional wrestling is not a sport, but rather theatrical entertainment. This allowed organizations like the WWE to avoid the strict regulations and taxes imposed on legitimate athletic competitions like boxing or MMA. By admitting the matches were predetermined, the industry saved a fortune. It's a rare moment where a judge officially ruled that "it's still real to me, damn it" is legally false in every sense. 25. A judge in Pennsylvania once ruled that a man could not be sued for stealing his neighbor's Wi-Fi because the signal was invading his property. The neighbor tried to press charges for theft of service, but the judge argued that if you broadcast a signal into someone else's living room, you can't really complain if they catch it. It's the digital equivalent of someone's tree branches hanging over your fence. If a signal is in your house, do you believe you have a right to use it? 26. In a bizarre ghosting case, a judge in Nevada ruled that a psychic could be sued for failing to predict the future. A client paid thousands of dollars for a guaranteed lottery win prediction that never happened. The judge ruled that while psychic powers are debatable, guaranteed financial results fall under consumer protection laws. If you promise a miracle and deliver a zero, the law treats you like any other crooked contractor. It's a rare moment where the legal system officially called out the crystal ball industry for its lack of accuracy. 27. A judge in Illinois once ruled that a person could be held liable for a car accident even if they weren't in the car. How? By distracting the driver via a text message. The ruling suggested that if you know someone is driving and you send them a message that requires an urgent response, you are partially responsible if they crash while reading it. It's a terrifying precedent that makes your "where you at" text a potential legal liability that could cost you thousands in damages. 28. In a case that sounds like a 19th century fever dream, a judge ruled that a man could legally marry his own stepmother. Since they weren't related by blood, the court found no legal reason to prevent the union. It's one of those technically legal but socially devastating rulings that leaves everyone in the courtroom feeling a little bit awkward. If the law allows it, does that make it right? Or just a very weird Thanksgiving dinner waiting to happen? 29. A judge in California ruled that a poop-themed emoji in a text message could be interpreted as a legally binding threat. In a harassment case, the defendant argued that emojis are just silly icons, but the judge disagreed, stating that in the context of the conversation, the smiling pile of poo was meant to intimidate. We have officially reached the era where a cartoon feces can be used as evidence in a court of law. It's a strange time to be alive and texting. 30. In a very strange intellectual property case, a judge ruled that a monkey cannot own the copyright to a selfie. A photographer left his camera unattended, and a macaque took a brilliant smiling photo of itself. PETA sued on behalf of the monkey, arguing he owned the image. The judge ruled that the Copyright Act does not extend to animals. Sorry, Mr. Monkey, no royalties for you. If an animal creates art, who do you think should actually own the rights? 31. In Tennessee, a judge officially ruled it illegal to import a skunk. While this seems like common sense, the ruling targeted those trying to keep these critters as exotic domestic pets. The court decided the risk of rabies and the public nuisance of the smell made skunks persona non grata by default. So if you were planning a skunk smuggling ring, Tennessee is definitely off your map. It makes you wonder exactly how many people were walking around with pet skunks before the gavel finally came down. 32. In a bizarre intellectual property ruling, a judge decided that a specific shade of blue can be legally owned by a single artist. This prevented anyone else in the world from using that exact pigment in their artwork without permission. The judge ruled that because the artist had spent years developing the chemical formula for the color, it was a trade secret and a protected asset. It's a terrifying thought that the very colors of the rainbow could eventually be locked behind a corporate paywall. 33. If you've ever wanted to be a pirate, don't move to South Carolina. A judge there once upheld a ruling that makes it illegal to work on Sundays unless you're doing work of necessity. One man was actually arrested and fined for disturbing the peace by simply painting his own house on a Sunday. The court ruled that unless your house is literally falling down, you must pick up the brush on Monday. It's a fascinating look at how old-school religious laws still lurk in the shadows. If you can't paint your house, are you even a homeowner or just a weekend tenant of the state? 34. In a bizarre 2014 ruling, a judge decided a woman could sue her nephew for negligent hugging during a birthday party. The woman claimed the 8-year-old boy jumped into her arms too forcefully, causing her to fall and break her wrist. While the jury eventually ruled in favor of the boy, the fact that a judge allowed a hugging lawsuit against a child to go to trial shows how litigious our society has become. It's a sobering thought that a family celebration could end in a deposition. Do you think a hug should ever be a legal liability? 35. A judge in Georgia ruled that a man could be arrested for swearing in front of a minor in a public space. While the First Amendment is generally strong, many states still have profanity laws that judges occasionally enforce with vigor. The man was shouting expletives in a crowded park, and the judge decided his right to speak ended exactly where a child's ears began. It's a reminder that, even in the land of the free, you should watch your mouth around kids. Sometimes the law requires you to keep your vocabulary strictly PG. 36. In an incredibly niche ruling, a Utah judge decided it is technically illegal to cause a catastrophe as a deliberate act. That's the entire law. Specifically, the court upheld a statute making it a crime to intentionally or knowingly cause a disaster like a massive flood or a localized explosion. It feels like a law from a vintage superhero comic, but it is a real part of the Utah legal code. It's comforting to know they've cleared that up. No causing world-ending catastrophes this weekend, everyone. It is always better to be safe than prosecuted. 37. A judge in Oregon once ruled that a man could not be evicted for having too many gnomes in his garden. The local housing authority claimed the hundreds of ceramic statues were a psychological hazard to the neighbors. The judge looked at the evidence and decided that as long as the gnomes weren't blocking the sidewalk or screaming, they were protected as personal lawn ornaments. It was a massive victory for eccentric retirees everywhere. 38. In a case about personal space, a judge ruled a man could sue his neighbor for hostile staring. The plaintiff claimed the neighbor would sit on his porch and watch him silently for hours, creating intentional affliction of emotional distress. The judge agreed that hostile staring could be considered harassment if it is persistent and clearly meant to intimidate. It's a landmark ruling for introverts who just want to be left alone in their backyards without an audience. Does a long, mean look count as a crime? 39. A New Jersey judge ruled a man was legally allowed to grow a meadow instead of a traditional lawn, despite neighbors' complaints. The town tried to fine him for not mowing, but the judge ruled his natural garden was a form of artistic expression and environmental activism. This was a massive win for biodiversity and people who hate spending Saturday mornings pushing a heavy mower. It set a precedent that your yard doesn't have to look like a golf course to be legal. It's the ultimate victory for the Let It Grow movement. 40. In a very strange DC ruling, a judge decided that luck is not a taxable asset, but winnings are. A man tried to argue that a massive casino jackpot shouldn't be taxed because he didn't work for it. He was simply blessed by fortune. The judge ruled that while the universe might have favored him, the IRS favors a percentage of everything. It's a sobering thought that even if you have a lucky rabbit's foot, the government still expects its cut of the magic. Apparently, even the supernatural has to fill out a 1040 form if it results in a check. 41. In a move that sounds like a plot from a low-budget horror movie, a New York judge ruled that a homeowner must disclose if their house is legally haunted. In the famous Ghostbusters case of 1991, the court decided that because the owner had widely publicized the home's paranormal activity in local media, the house was legally haunted as a matter of law. You can't sell a house and keep the poltergeists a secret if you've already told the newspapers about them. 42. In a legendary display of judicial literalism, a judge in Pennsylvania ruled that a toilet is not a structure, but is, in fact, a piece of furniture. A man was facing heavy fines for violating zoning laws by placing a porcelain throne in his front yard as a makeshift planter. The judge looked at the local building codes and realized they didn't technically forbid outdoor furniture. Because the toilet wasn't bolted to a foundation, it was legally no different than a lawn chair. It's a hilarious loophole that allowed a man to keep a bathroom fixture on his lawn just to spite his neighbors. 43. A judge in Iowa once presided over a case where a man tried to sue himself for $20,000. He claimed that his negligence led to him tripping over his own garden hose, and since he had liability insurance, he figured he could just collect the payout from his own policy. The judge threw the case out, ruling that a person cannot be both the plaintiff and the defendant in the same lawsuit. It's the ultimate galaxy brain move that unfortunately didn't result in a payday. If you could sue yourself for every time you forgot where you put your keys, would you be a millionaire? 44. In an incredibly strange 1994 ruling, a judge decided that the Sandman was legally responsible for a car accident. A driver who fell asleep at the wheel tried to argue that an external supernatural force caused his slumber. Surprisingly, the judge didn't just throw him in jail. The court had to spend hours debating the legal definitions of acts of God versus personal negligence. Ultimately, the judge ruled that if you're tired, it's your job to pull over, regardless of which folklore character you think is sprinkling dust in your eyes. Common sense finally won the day. 45. A judge in California once ruled that a man could be charged with a DUI for riding a motorized cooler. The vehicle in question was a standard blue ice chest fitted with a small engine and 4 wheels, used to transport beer around a campsite. When the man took it onto a public road, the court ruled that because it was self-propelled, it met the legal definition of a motor vehicle. It's a tragic end to a very creative way to carry your drinks. 46. In a very weird animal rights case, a judge ruled that a man could not be convicted of breaking and entering because the witness was a parrot. The bird kept screaming, "He's in the house," and naming the suspect, but the judge ruled that a parrot cannot be cross-examined, and therefore its testimony is inadmissible hearsay. The suspect actually walked free because the only person who saw him was a green bird with a big mouth. It's a masterclass in how legal technicalities can sometimes favor the criminal, especially when the witness has feathers. 47. A judge in Washington, D.C. once presided over a case where a man sued a dry cleaner for $54 million over a lost pair of pants. The plaintiff claimed that the satisfaction guaranteed sign in the window created a legally binding contract that the cleaners had breached. The judge eventually ruled against the man, but not before the case dragged on for years, nearly bankrupting the small business owners. It's a sobering reminder that ridiculous rulings often start with ridiculous lawsuits that should have never left the laundry room. 48. In a massive blow to vampire enthusiasts everywhere, a judge in Florida ruled that a man could not use being a 500-year-old vampire as a legal defense for a noise complaint. The man claimed that his nocturnal lifestyle and loud organ music were part of his religious identity as an undead creature. The judge was not impressed. ruling that even the children of the night have to follow local noise ordinances. It's a hilarious example of someone trying to use fantasy tropes to escape a $200 fine. Apparently, being immortal doesn't exempt you from being a good neighbor. 49. In a case that defined finders keepers, a judge ruled that a man who found $150,000 inside a wall he was renovating didn't actually get to keep it. The money was hidden there by the previous owner decades ago. The judge ruled that because the money was mislaid rather than lost, it still belonged to the estate of the person who put it there. The renovator got nothing but a legal bill and a very disappointing story to tell at parties. Alright, we've covered 49 points of absolute legal madness, and there is only one left. But before we get to number 50, it's time for the final verdict. In our opinion, the award for the most incredible rule from today's list goes to the California ruling that bees are technically fish. Why? Because it represents the absolute peak of legal gymnastics, where words no longer mean what they mean just to achieve a specific result. Do you agree with our verdict? Let us know in the comments. And now, our final number. 50. In one of the most heartwarming yet ridiculous rulings ever, a judge in Michigan once allowed a service pony to fly in the first-class cabin of a commercial airplane. The judge ruled that because the miniature horse was trained to assist its owner with a disability, it met all the legal requirements of a service animal under the ADA. This meant other passengers had to share their legroom with a hoofed mammal. It's a reminder that the law can be incredibly flexible when it wants to be, even if it results in a horse eating peanuts at 30,000 feet. From haunted houses to litigious toddlers, these cases prove that legal truth is often stranger than fiction. These rulings show that while the law is designed to be fair, it is ultimately shaped by humans with a very bizarre sense of logic. It makes you wonder, is the American legal system actually designed for justice? Or is it just a giant expensive joke? Drop a comment with your thoughts. Stay smart, and we'll see you in the next one.
The most prominent and widely advertised failed reward claim for the Freedom Law School's $300,000 income tax reward involved Jonathan R. Siegel, a law professor at George Washington University Law School. Background of the claim. In April 2016, Professor Siegel contacted Payman Motaheda, founder and president of Freedom Law School, after becoming aware of the long-standing reward offer. Siegel, who has expertise in federal courts and administrative law, attempted to claim part or all of the reward by arguing that the existing provisions in the Internal Revenue Code, particularly 26 U.S.C. Section 6012, persons required to make returns of income, and related sections like Section 1, imposition of tax, and Section 6011, satisfy the requirement to show the specific statute that makes U.S. citizens liable to file and pay income tax on wages, salaries, or labor earned in the United States. Freedom Law School had offered the reward, broken into $300,000 propositions, since around 1999 and 2000, challenging claimants to prove the exact statute requiring the average American to file a return and pay income tax on domestic earnings, related liability, and enforcement aspects, often framed in ways that distinguish between direct taxes, federal privileges, or specific classes of income and taxpayers. Siegel submitted a formal claim via email, correspondence, citing the relevant U.S. Code sections, and arguing they clearly impose the filing and payment obligations when gross income thresholds are met. Why the claim failed, according to Freedom Law School. Payman Motaheda personally reviewed and adjudicated the claim, as he states he does for all attempts. Freedom Law School denied it, maintaining that Siegel's submission did not meet their specific criteria for the reward. They published a detailed, multi-part series on their website, with email exchanges, the claim itself, and their rebuttal, titled Law Professor Fails to Collect Freedom Law School's Income Tax Reward, Parts 1 to 3, released in 2016.
my consent, and you cannot legally process me through this courtroom without this name in all capital letters that was issued without my consent.
I just have a question. What is your goal? What are you going to do?
I'm not the person, sir.
Okay,
I am not
the
the
person,
person.
David Hall. Tell him he's not leaving jail either, all right?
Oh, that was so good. What's up, everybody? Mark Breyer, the Husband Wife Law Team, your own real-life personal trial lawyer who actually goes to court for people. You know some lawyers, but you don't know many trial lawyers because most lawyers don't go to court and fight.
Gasp.
So I have a lot of fun sharing my thoughts with you. Don't forget to subscribe. I want to thank all of you. Thousands and thousands of people are subscribing since I last talked to you. I appreciate it so much. We are zooming to 100,000 and beyond, which I love and I appreciate. So if you're one of the ones that is not subscribed for some reason, ask yourself, why is that? As you click subscribe. Also, it's of no value if I share with you things you don't want to hear the most. It helps me a lot if you comment. Tell me what you like, what you don't like. I care a lot about what it is that you most want to hear. Now today, I'm responding to a whole bunch of comments. We had a sovereign citizen video. For those who don't know about the sovereign citizens, hang tight. We're about to see some of them. They don't actually exist except for in their minds and on the internet with each other. A lot of you have asked for my comments on these, so let's get into it. I had a lot of fun last time and we're gonna do a lot more of them together. So here we go.
We're in Placerville, California, for the arraignment of 39-year-old Asher Edwards.
Hello, Judge.
Good afternoon, sir.
Edwards' demeanor may seem pleasant, but just a few days earlier, his alleged behavior was anything but. He was charged with making terrorist threats, assault with a deadly weapon, and obstructing peace officers after a domestic disturbance escalated into a 2-day police standoff.
2 days. Man, that is a long standoff. 2 days. You got to have enough food and water to get yourself. 2 days, you didn't go to sleep?
Engaging suspect!
That is a serious standoff. And by the way, credit to the police officers because I'm sure many of them wanted to just go in and take this dude out, but this is not Hollywood. And so give them some credit because people are quick to point out where they make a mistake. But in this case, they stood back. Apparently nobody got hurt beyond what started it. That's good news.
Mr. Edwards, this is the time and place set for your arraignment. Do you consent to have an arraignment by video conference?
Sir, is this an maritime admiralty law courtroom that we're processing me through?
No, it's not.
The judge already knows. So let's start breaking this down. We're gonna go through a lot of these, but let me give you an analogy. Someone points a gun at me. If they shoot me, but I refuse to accept the fact that the bullet will hurt me, will the bullet hurt any less? Nope. So if you go to a courtroom where they have bars and cells and handcuffs and you are outnumbered and outmanned, and then you go into a courtroom that has procedures and laws and you say those laws don't apply to me, will those laws apply to you any less? No. What if you and your friends on the internet all came up with reasons why it doesn't apply to you? Will you go to jail any less? No, you're gonna go to jail more. Let's watch how this happens.
Edwards considers himself a sovereign citizen who lives as a free man, as they like to say, under common law as established by the Founding Fathers. Maritime admiralty law that he's referencing is the law of the sea and international commerce, a body of law that sovereign citizens believe to be the foundation of the country's modern legal system, which they reject.
This is not a maritime admiralty law courtroom. I believe so.
No.
Absolutely, it is. All courtrooms in this country are maritime admiralty law courtrooms that process people, aren't they?
Now, what good is it going to do to you to say to this man who's got a robe on, he's a judge, he's bounded by the laws that you refuse to accept? Do you think you're going to convince the judge now to back off the entire legal system that's been formed from the state of California and the United States of America because you, the guy who's been charged with all these terrible crimes, convinces him otherwise? I don't think this is going to end so well.
No, sir.
That's false information. Well, either way, this courtroom is trying to process me as state property. See this fictitious name statement? Asher Edwards spelled in all capital letters? This is not my name.
Edwards is referring to another sovereign belief that beginning at birth, one is issued a government identity, meaning one's name is spelled in all capital letters, such as on a birth certificate or social security card, and that doesn't represent one's true or free self.
Yeah, those capital letters really steal your rights.
Without my consent, and you cannot legally process me through this courtroom with this, without this name in all capital letters that was issued without my consent.
I just have a question. What is your goal? What are you going to do? Like in your mind and your friends' minds, you sit around saying that the laws don't apply to us. Does he think the judge is going to go, I can't do that without your consent? Let him go. He made a really good point. Like, what is the end game here? Do you know how many people are sitting in prison right now, all telling each other that the government doesn't have the right to keep them in prison? You're still in prison.
My name is spelled Asher Edwards, first capital, all lowercase, Edwards, first capital, all lowercase, and this is the birth name given to me by my parents, protected by the Constitution of the United States.
By the way, you guys know why the judge is really calm during this? Because he's heard it all before. For a bunch of other people that are sitting in jail or prison right now, because their friends made up on the internet things that don't apply to them that do.
Therefore, it is illegal for you to process me through this courtroom, so you guys have to figure out something else to do with it.
But this judge is all business, so figuring out something else to
You guys are going to figure out something else. All right, I just figured out you're going to jail. Peace.
Court will enter a not guilty plea on your behalf. Will show time is not waived. We'll set this matter for pre-preliminary hearing within the statutory period.
And I would like to see the gun. It said I had a gun. I've never had a gun.
As Edwards continues his rant about the alleged gun, the judge reaches for his own weapon of choice, the mute button.
They're lying.
Do not speak while I am speaking, sir. sir.
Edwards continues to plead his case, but to no avail.
Court will set bail in the amount of $72,500.
You know what? I'm a little surprised it was not a higher bail because the man doesn't think the law applies to him. He was charged with some really violent stuff. I could have seen that being a much higher number. Also, if I can nitpick just for a minute as a lawyer, I'm not a big fan of muting through a video conference, and let me tell you why. Because the video conference is supposed to basically be a more convenient way for us to get things done in our court system without having to show up. But it's not supposed to change the ability to be there to fight for your rights and to defend yourself. Forget the fact that I think this man's views of the laws and how they apply to him. I could not disagree more than I disagreed. But if he's sitting in your courtroom, you can't mute him. Now you can say, if you don't stop, I'm going to take you out of the court. He could have done that here. I'm not a big fan of using technology to mute him. First of all, he may say something that incriminates himself. Or maybe he'll say something that actually makes you realize that there's more investigation to be done. By the way, I'm not attacking this judge who remained calm in spite of the nuttiness, but I just want to point out that I think we should discourage the use of a mute button against litigants or their lawyers in a virtual setting.
How do judges figure out the bail now?
This is how they figure out the amount of bail. How much is it going to take for the person to come back? And you have to know how much money the person has. $75,000 to a multi-millionaire makes no difference whatsoever. $75,000 for most Americans means you're staying in jail. And so you have to consider how much is it to this person. If this person has to put up their house, that